comes together under a common belief to establish an institution will be entitled to rights under Article 26. So here's one question for my lords to consider. If 26 had not been there, what would have happened? Right. Therefore, it was always meant to be limited in its application. I'm just reiterating the point over and over again, that it never severs the umbilical cord that connects 25 and 25 throughout its entire history. And then my lady would see how that language gradually changes.
That is because it becomes diluted.
Courts have been grappling since 1954 on the question of how do we interpret denomination. And Shirurmat has given the impression that denomination is something exalted, which is distinct and unique. Dr. Ambedkar and K. Munshi were not of this view because 26 was meant to be a specific application of 19(1)(c) in a religious context, which is freedom of association is provided in 19(1)(c) and the limitations on freedom of association are in 19(4). 26 was meant to be a freedom to religiously associate. So in that sense, 26 is a specific manifestation of 19(1)(c) in a religious context. And therefore, denomination was never used in the context of giving it a separate character altogether. And I'll show my lords. Please, I'm so sorry. My lords had a question.
No.
Please, minutes. And this will emanate from the clauses proposed by Dr. Ambedkar on 24th of March 1947, page 4, para 7. What I'm trying to do through this endeavor is to show we need not go down the path of interpretation and get caught in the question of what is a denomination when those questions have already been answered by the history of the provision. I've gone through all the written submissions. In my humble view, this portion or this history was not there, and therefore I thought this could put the matter to bed. Now kindly see this. My lords would see 14, 15 onwards. Can I just read this for the court's benefit? These are the proposals under Dr. Ambedkar's note of 24th of March 1947. Under the heading Fundamental Rights of Citizens, I've given the relevant page numbers from the existing compilation of the court. The state shall guarantee to every Indian citizen liberty of conscience and the free exercise of his religion, including the right to profess, to preach, and to convert within limits compatible with public order and morality. This is more or less Article 25. Now kindly see 18 onwards. Clause 18, 19, and 20 shed abundant light on the predecessor to Article 26. Persons following a religion shall be guaranteed freedom of association and shall have, if they so desire, the right to call upon the state to pass legislation in terms approved by them, making them into a body corporate. Can I request my lords to turn the leaf and kindly see clauses 19 and 20. Every religious association shall be free to regulate and administer its affairs within the limits of the laws applicable to all. Religious associations shall be entitled to levy on their members, contributions on their members. This is not relevant. 18 and 19 show that denomination was preceded by religious association, which is why in the debates, my lords would not find a specific discussion on what would amount to a denomination. Because a denomination is always meant to be understood as a collective expression of individual rights. Therefore, every body of people which comes together under a common belief to establish an institution will be entitled to rights under Article 26. So here's one question for my lords to consider. If 26 had not been there, what would have happened? It would have been still part of 25(1), except that they decided to pull it out of 25(1) and give it a separate character for one good reason. Because part 3 can be applied to 25, but part 3 cannot be applied to 26. And that is conspicuous in the absence of the language itself. Therefore, to ensure that collective rights or denominational rights or associational rights are not fettered by the limitations of 25(1), the bundle of rights within 25(1) were plugged out and carved out as Article 26. And there is a discussion to this effect. Therefore, the submission before my lords is, there is a very conscious reason for keeping 26 as a separate right as opposed to 25(1). There is a conscious reason for making rights under 25(1) subject to part 3, but not 26. And the word denomination does not have a definition in the Constitution because it was always meant to be understood as a collective or an association. Now, my lords may kindly come to the paragraph under the indented paragraph at page number 5, just about para 8, which is my statement. I request my lords to kindly make a note of this. Draft clauses 18 to 20 of Dr. Ambedkar's draft contain the germ of Article 26, which indicates that denomination has been referred to as religious association and has not been subjected to any higher standard as required by Shirur Mat. Then my lords may come to para number 8. Again, K.M. Munshi on 26th of March 1947 puts forth before the subcommittee of fundamental rights Article 6. I request my lords to make a note of Article Roman 6 because it is this Article Roman 6 that becomes Article 1314 at some point, Article 1920 at some point, Article 2021 some point, and then becomes 2526. That is the journey of this entire thing. Now kindly take a look at the language here. This will show that 25.2 is only subject to 25.1 once more. Rather, it applies only to 25.1. All persons are equally entitled to freedom of conscience and the right freely to profess and practice religion in a manner compatible with public order, morality, or health. The right to profess and practice religion shall not include economic, financial, or political activities associated with religious worship. My lord sees that. Then, so what was given as a proviso is then fused into a composite provision. Then my lords may come to the next page. At para number 9 on page number 6 is the revised version of Article 26 introduced as part of Sri B.N. Rao's draft. Please see what it says. Every religious denomination shall have the right to manage its own affairs in matters of religion and to own, acquire, and administer property, immovable and movable, and to establish and maintain institutions for religious or charitable purposes consistently with the rights guaranteed in this Constitution. This becomes later in accordance with law under 26D. Now, my lords would see what is missing here is, my lords would see that public order and morality is completely missing here in this particular draft. That gets introduced later. So I'll show that. Now, my lords may come to para number 10 at page number 6. This is the combined draft of Article 6, which is the future Articles 25 and 26, as adopted on the 26th of March 1947. My lords would see that clause 1 of Article 6 is proto-Article 25, or the predecessor to Article 25, rather 25.1. Then my lords would see that the explanation with respect to Kirpans has already come. And please see, 25.2 was then inserted as an explanation to clause 1. Right. Therefore, it was always meant to be limited in its application. I'm just reiterating the point over and over again, that it never severs the umbilical cord that connects 25 and 25.2 throughout its entire history. It becomes an explanation, it becomes a proviso, then it becomes 25.2. That's the only difference. Then kindly see this. This is the new clause that Sri B.N. Rao recommends at the bottom of Article 26. My lords could see, kindly see the bottom of page number 6. Every religious denomination shall have the right to manage its own affairs in matters of religion, so on and so forth. My lords has already seen that. Now I request my lords to come to the next page.
Where it says consistently with the rights guaranteed in this Constitution.
And then my lady would see how that language gradually changes.
That is because it becomes diluted.
I'm so grateful. It becomes diluted. And not just that, wherever it refers to clause 6, that is clause 1 of Article 6, which is 25.1, initially it kept saying subject to the rights in this chapter. That chapter becomes part later because everything is reworded. So chapter becomes part. And I'll show all of those changes as well. Kindly come to the next page. Para number 11 at page number 7. My lord sees that.